The Supreme Court chamber fell silent as Jasmine Crockett approached the podium, her crisp navy suit standing out against the deep mahogany backdrop. Cameras zoomed in on her calm, confident smile, a sharp contrast to the tension that gripped the room. Moments earlier, Justice Stephen Breyer had stunned the courtroom by interrupting the opposing counsel with an unexpected statement. "I want to hear what Representative Crockett has to say." Her legal analysis in her brief was exceptional. The conservative justices shifted uneasily. Chief Justice Roberts raised an eyebrow, but what followed sent ripples through the legal world. As Crockett opened her case file, Justice Breyer leaned forward and said words no one expected from the 83-year-old jurist. "Congresswoman, your constitutional interpretation challenges decades of precedent in ways I cannot dismiss. Please explain it to my colleagues." The gallery erupted in whispers until officers restored order. Crockett stood firm, eyes steady, preparing to deliver an argument that would silence critics and forever reshape how the court viewed this rising congresswoman from Texas. Before we dive deeper into this extraordinary moment, don't forget to like and subscribe for the latest political analysis and Supreme Court coverage. Representative Jasmine Crockett was no stranger to high-stakes legal battles. Before her election to Congress, she had earned a formidable reputation as a civil rights attorney in Texas, taking on cases others called unwinnable. Her meteoric rise, from the Texas legislature to the U.S. House, was fueled by viral clips of her sharp questioning and her ability to simplify complex legal issues for ordinary Americans. But today's appearance was unlike any before. The case centered on voting rights restrictions that disproportionately affected minority communities, a pattern Crockett had spent her career fighting. For weeks, conservative media dismissed her as inexperienced and unqualified to challenge legal precedent. "She's a freshman congresswoman playing lawyer at the Supreme Court," mocked one commentator. "Breyer will eat her alive." Justice Stephen Breyer, serving his final term before retirement, had built a legacy as a pragmatic liberal focused on how laws work in practice. Known for his philosophical questions and intellectual rigor, his influence shaped American jurisprudence across decades. But that morning, observers noticed something different. He was practically studying her, court reporter Nina Totenberg later recalled. Her brief was worn, highlighted, filled with his handwritten notes. Few realized Crockett had spent months crafting a novel legal theory that challenged recent voting rights rulings without directly attacking the conservative justices who wrote them. Drawing from overlooked Reconstruction-era legal principles and historical texts, her argument was both innovative and grounded. The stakes were enormous. Millions of Americans' voting access hung in the balance. Failure meant restrictive laws would stand, shaping elections for years. Conservative legal groups filed amicus briefs calling her theories dangerous and radical. As Crockett arranged her papers, Justice Samuel Alito leaned toward Justice Thomas and whispered something that drew quiet smiles. Justice Barrett tapped her pen impatiently. Only Breyer's eyes remained fixed on Crockett, as if he saw what his colleagues had missed. "Congresswoman Crockett," Chief Justice Roberts began, "you have 30 minutes to present your argument. I remind you this court has already addressed these issues recently." "The precedent is clear," Crockett nodded. "Thank you, Mr. Chief Justice. Yes, I'm well aware of the court's precedents. That is precisely why I'm here today." The stage was set for a confrontation unlike anything the Marble Chamber had witnessed in years. Crockett began steadily, her voice calm and deliberate, far removed from the fiery tone seen in congressional hearings. "Justices," she said, "I direct your attention to Section 2 of the Voting Rights Act, which this court has previously interpreted as requiring proof of discriminatory intent, rather than merely discriminatory impact." Justice Alito interrupted almost instantly. "Congresswoman, that's settled law from just 2 terms ago. Are you asking us to overturn our own precedent?" His tone carried quiet condescension. Crockett didn't flinch. "No, Justice Alito, I'm asking you to apply it correctly." She produced a document absent from the main briefs. This statistical analysis wasn't available during that case. It demonstrates that, even under your own test, discriminatory intent remains evident in a pattern explainable only by race. The tension rose. Challenging Alito directly was bold. Observers exchanged glances. Was this performance or a serious legal breakthrough? Then in a rare moment, Justice Thomas spoke. "Congresswoman, these statistics could be read multiple ways. What makes your interpretation the correct one?" Before Crockett could reply, Justice Breyer interjected, "Actually, Justice Thomas, the methodology aligns with what this court accepted in Johnson versus United States, 1987. It's sound." Turning toward Crockett, he added, "Please continue, Representative." The exchange was extraordinary, a liberal justice appearing to shield a congresswoman from conservative scrutiny. Reporters scribbled frantically. Something historic was unfolding. Crockett pressed on, building her argument step by step. She cited little-known precedents that forced the justices to flip through their materials for reference. When Justice Barrett challenged her interpretation of a 1980s decision, Crockett responded by quoting Barrett's own law review article from her academic years. Ironically, one that supported Crockett's stance. The chamber fell silent. Even her critics were forced to acknowledge that Jasmine Crockett had not only mastered the law, she had redefined how it could be argued before the nation's highest court. Justice Barrett, I believe you wrote in 2006 that statistical patterns of this scale create a presumption that shifts the burden to the state to prove there was no discriminatory intent. So I'm simply applying your scholarly framework to these facts. Barrett looked momentarily surprised, clearly not expecting her own academic work to be used in this context. The tension in the courtroom rose as Crockett calmly dismantled each conservative argument. She wasn't speaking for the cameras or relying on emotion. Her approach was methodical and deeply analytical, showing a level of legal precision few had anticipated. Justice Kavanaugh took a different tack. "Congresswoman, even if we accept your statistical analysis, doesn't the state have a compelling interest in preventing voter fraud? These measures appear narrowly tailored to that end." It was a strategic question, intended to corner Crockett into seeming dismissive of election integrity concerns, a narrative that conservative media would likely amplify later that evening. The audience grew still, waiting for her response. Crockett smiled faintly. "Justice Kavanaugh, I'm glad you raised that point." She reached for another document. "I've reviewed every voter fraud prosecution in this state over the past 20 years. There were exactly 13 cases, and none would have been prevented by these measures." She paused briefly. "However, these policies would block an estimated 740,000 eligible voters from casting ballots. If we're discussing narrow tailoring, I'd suggest this is the opposite." Justice Breyer nodded subtly. The conservative justices exchanged glances. As Crockett's time neared its end, Chief Justice Roberts, who had remained quiet throughout, finally spoke. "Congresswoman Crockett, your statistical analysis is compelling, but this court has been hesitant to intervene in state election processes without a clear constitutional violation. It was the opening she had anticipated." "Chief Justice, I understand the court's caution," Crockett replied evenly. "That's why I've saved my most important argument for last." She opened her briefcase and produced a bound historical record unfamiliar to the justices. This is a recently uncovered transcript of congressional debates during the drafting of the 15th Amendment. It includes statements from the amendment's authors directly addressing the types of state actions at issue today. The justices looked surprised. Documents from that era were rare, and newly authenticated records shedding light on original intent were taken very seriously by the court. "I've had this verified by historians at 3 universities," Crockett continued. "It shows that the framers of the 15th Amendment specifically intended to stop states from imposing procedural barriers that disproportionately affected newly freed citizens' right to vote, even when those laws didn't explicitly reference race." Justice Breyer leaned forward. "May I review that document, Congresswoman?" he asked. Crockett nodded, passing it to the clerk, who carried it to the bench. The atmosphere grew tense once more. She had reserved this revelation for the closing moments, a move that could either powerfully strengthen her case or be seen as a last-minute gamble. Breyer studied the document carefully, his expression shifting from curiosity to visible engagement. The other justices watched closely, clearly unsettled by both the unexpected evidence and Breyer's reaction. "Justices," Crockett said, as the red light indicated her time had expired, "I believe these records provide the precise constitutional foundation the Chief Justice referred to. The framers of the 15th Amendment foresaw this very issue and explicitly acted to prevent it. Normally, the Chief Justice would thank her and conclude the session, but this time Justice Breyer spoke up. "Mr. Chief Justice," he said, "I believe the court would benefit from allowing the Congresswoman additional time to explain this historical evidence." "It's quite extraordinary." The courtroom fell silent. Extended speaking time was rarely permitted, especially at the request of a justice. All attention turned toward Chief Justice Roberts, whose response would indicate how seriously the court regarded Crockett's argument. Roberts hesitated briefly before nodding. "5 additional minutes, Congresswoman," he said. "Please focus specifically on how this historical document relates to our current jurisprudence." As Crockett began her extended remarks, the legal correspondents present realized they were witnessing something exceptional. The tone in the courtroom had shifted. The Congresswoman, once dismissed by critics, now held the attention of the highest judicial body in the country, with one of its most respected justices openly supporting her line of reasoning. None could have anticipated what would follow. Standing composed at the podium, Crockett viewed the extra 5 minutes as an unexpected opportunity. The historical document she had presented had clearly drawn Justice Breyer's interest, though the remaining justices still appeared cautious, some intrigued, others doubtful. "Justices, I direct your attention to page 37 of this congressional record," Crockett began, her tone steady and deliberate. "Senator Charles Sumner, one of the architects of the 15th Amendment, stated, 'The amendment must not only forbid direct racial barriers to voting, but must empower Congress to address indirect measures that achieve the same result through procedural means.'" Turning the page, she continued. And here Representative Thaddeus Stevens expands further. "A state may claim neutrality, such as preventing fraud, yet design measures that disproportionately burden freedmen. The amendment must address such evasions." Justice Thomas leaned forward. "Congresswoman, while this history is interesting, how do these statements alter our analysis when this court has consistently held that disparate impact alone does not invalidate election laws?" It was the moment Crockett had prepared for, the opportunity to deliver her key argument. "Justice Thomas, that is precisely why these documents are critical," she replied. "The framers of the 15th Amendment did not limit their focus to overt racial discrimination. They intentionally considered voting procedures that, though neutral on their face, created unequal burdens." She paused, meeting each justice's eyes. "But I am not asking the court to rely solely on disparate impact. These records show that the original understanding of the 15th Amendment included what we might today call a burden-shifting approach. Once certain statistical thresholds were reached, Justice Breyer's eyes widened slightly as he flipped to a section he had marked. "Congresswoman," he asked, "are you referring to Senator Howard's remarks on page 42? Crockett smiled. He had found it himself. "Exactly, Justice Breyer. Senator Howard proposed that when a voting procedure decreases participation among black voters by more than 1/3 compared to white voters, the state must prove a compelling and necessary justification. This aligns closely with standards the court already applies in other constitutional contexts," Justice Barrett interjected. "But, Congresswoman, even if we accept that this reflects the original intent, the court's jurisprudence has evolved over the past 150 years. Are you suggesting we abandon established precedent?" "Not at all, Justice Barrett," Crockett answered smoothly. "This historical evidence shows that the court's modern framework has diverged from the original meaning of the 15th Amendment. Reconnecting with that foundation would actually make the court's voting rights jurisprudence more coherent." She then presented a chart from her legal brief that had not yet been discussed. "This data demonstrates that applying the original interpretation would affect only a narrow category of voting laws, specifically those producing the most severe disparate impacts. The majority of election regulations would remain unchanged." Justice Kavanaugh, visibly uneasy, shifted tactics, preparing another line of questioning. "Congresswoman, even if we find your historical analysis convincing, what's the limiting principle?" one justice asked. "Would this approach invalidate all voter ID laws?" "No," Crockett replied confidently. "Only those that meet the statistical threshold and where the state cannot demonstrate a necessary and compelling purpose." Many voter ID laws would withstand this scrutiny if states provide free identification and ensure equal access. She was clearly prepared, anticipating each question before it could become an obstacle. The gallery watched as Crockett methodically addressed and dismantled every objection. Chief Justice Roberts, known for preferring narrow rulings over sweeping opinions, leaned forward. Couldn't we decide this case more narrowly, without reconsidering our entire voting rights framework? It was the kind of question that usually hinted at his search for a middle ground resolution. Crockett seized the opportunity. Mr. Chief Justice, yes, the court could take that approach. The statistical evidence alone, under existing precedent, supports a ruling in our favor. However, she continued, I would respectfully suggest that the historical record offers this court an opportunity to bring clarity and coherence to an area of law that has become fragmented and difficult for lower courts to apply consistently. Then came the moment that silenced the courtroom. Justice Breyer, who had been carefully reviewing the historical materials throughout Crockett's argument, closed his binder and looked at his colleagues. I've spent nearly 3 decades on this court trying to understand the original meaning of our Constitution's protections for voting rights, he began, his voice resonating through the chamber. And I must say, in all my years, I have never encountered historical evidence this persuasive on this particular issue. The statement hung in the air. Breyer, typically known for his pragmatic rather than originalist reasoning, was endorsing Crockett's historical argument on originalist terms, directly addressing the conservative justices in their own judicial language. Congresswoman Crockett has not only uncovered a historical record previously overlooked, he added, but she's demonstrated how it can fit within our existing legal framework without causing the kind of judicial disruption some might fear. Justice Alito, visibly uneasy with Breyer's comments, interjected, Justice Breyer, are you suggesting we overturn our decision from just 2 terms ago, based on a document that wasn't even included in the original briefing? Before Breyer could answer, Crockett responded calmly, Justice Alito, if I may, I'm not asking the court to overturn that decision. That case focused on whether discriminatory intent was required. The court said yes, and I accept that precedent. Her tone was steady but carried firm conviction. What I'm showing is that the statistical patterns in this case do satisfy the intent standard when analyzed properly. The historical record simply provides constitutional context for why that framework is correct. It was a sharp and strategic reframing, acknowledging the court's authority while providing them a path to rule in her favor without explicitly reversing precedent. Breyer nodded approvingly. Exactly. Justice Alito, we wouldn't be overturning precedent. We'd be applying it with a fuller understanding of the constitutional provision at stake. The atmosphere in the courtroom had shifted entirely. What began as a routine argument by an underestimated Congresswoman had transformed into a masterclass in constitutional reasoning, one of the court's most respected justices, now openly supporting her approach. As her time concluded, Chief Justice Roberts spoke, his tone markedly more respectful than before. The court thanks you for your thorough presentation. Congresswoman. Crockett gathered her materials, exchanged a brief glance with Justice Breyer, who offered a subtle nod of respect, and returned to her seat. The opposing counsel, preparing to argue next, looked visibly unsettled. The state's attorney had expected to counter traditional voting rights arguments, not a historically grounded originalist case, now validated by Justice Breyer himself. In the press section, reporters rushed to send updates to their editors. Something remarkable had just occurred, and the headlines were already taking shape. Breyer endorses Crockett's groundbreaking constitutional argument, unexpected alliance on voting rights. What unfolded after the oral arguments in the justices' private conference room proved even more remarkable. 3 days later, the Supreme Court's press office issued an unprecedented announcement with far-reaching implications. The justices had requested supplemental briefs on the historical evidence presented by Congresswoman Crockett. Constitutional scholars across the political spectrum immediately recognized the move as extraordinary. The court rarely calls for additional information after oral arguments have concluded, and when it does, it usually signals a potential shift in the justice's approach to a case. Behind the closed doors of the Supreme Court, Crockett's performance was reverberating through the marble halls. According to sources speaking anonymously, the justices' post-argument conference was unusually tense. Justice Breyer was more forceful than usual, one insider revealed. He told his colleagues that disregarding Crockett's historical evidence would amount to intellectual dishonesty of the highest order, a striking statement from a justice known for his collegial tone. Meanwhile, back on Capitol Hill, Congresswoman Crockett returned to find her office overwhelmed with media requests and non-stop phone calls. CNN, MSNBC, and even Fox News were competing for interviews. Overnight, her social media following exploded, with the hashtag #JaiCrockettConstitution trending nationwide. "I simply presented the facts and the law," she told reporters outside her office. "The Constitution doesn't belong to one party or ideology. It belongs to all Americans. Its protections should apply to every voter, regardless of race or ZP code." Initially, conservative commentators sought to downplay Crockett's performance. "Political theater from a freshman congresswoman," declared one Fox News host. Yet, legal experts from across the political spectrum viewed it differently. Harvard law professor Alan Dershowitz, hardly a liberal partisan, told CNN, "What Congresswoman Crockett presented was a masterful blend of historical research and constitutional reasoning. The court will find it difficult to ignore evidence this compelling." Prominent conservative scholar Randy Barnett tweeted, "As an originalist, I find the newly uncovered 15th Amendment debates fascinating and potentially significant for our understanding of voting rights jurisprudence." Inside the court, opinions were split. Justice Thomas, who had initially dismissed the argument, asked his clerks to verify the authenticity of Crockett's documents and research their historical context. Justice Barrett, whose own academic work had been cited by Crockett, was reportedly re-examining the statistical data within the historical framework. 2 weeks after oral arguments, Justice Breyer made an unexpected appearance at a judicial conference at Yale Law School. Although Supreme Court justices generally avoid discussing pending cases, Breyer spoke broadly about constitutional interpretation. "At times," he said, "new evidence or analysis can challenge our established understanding. When that happens, intellectual honesty demands that we consider whether our precedents have drifted from the Constitution's true meaning. This is not about politics, it's about fidelity to law." Everyone in attendance understood the subtext. Without naming Crockett or the case, Breyer signaled that her arguments merited serious consideration. The political impact was growing. Voting rights organizations rallied behind Crockett, launching a national campaign titled "Stand with Jasmine" to emphasize the case's importance. Civil rights groups held prayer vigils outside the Supreme Court. Former President Barack Obama praised her brilliant and principled advocacy in a tweet that went viral. On Fox News, Representative Jim Jordan criticized Crockett's actions, calling them another attempt by the radical left to federalize elections. But when pressed to address the specific historical evidence she had presented, Jordan hesitated, admitting, "I haven't reviewed those documents personally." 3 weeks after oral arguments, the story took another major turn. The Washington Post published a detailed investigation confirming the authenticity of Crockett's historical materials. They had been found in a previously uncatalogued archive belonging to Frederick Douglass, who had attended several of the original congressional debates surrounding the 15th Amendment. The Post headline read, "Crockett's bombshell evidence confirmed authentic by historians." That same day, in a rare move breaking with court protocol, Justice Clarence Thomas spoke at a Federalist Society event. Without mentioning the case, he emphasized the importance of original understanding in constitutional interpretation. "When clear historical evidence reveals the original public meaning of a constitutional provision," he said, "judges have a duty to align their interpretations with that understanding, even if it requires re-evaluating precedent." Legal observers were astonished. Was the court's most conservative justice signaling openness to Crockett's argument? Speculation intensified across the legal community. 45 days after oral arguments, the Supreme Court announced that it would release its decision the following Monday. The extended time between argument and decision suggested complex opinions were being drafted, and that votes may have shifted during deliberations. The night before the ruling, Congresswoman Crockett appeared on 60 Minutes. Speaking calmly, she said, "Whatever the court decides tomorrow, I believe we've already changed the national conversation about voting rights. These aren't abstract legal theories. They determine whether millions of Americans can exercise their most fundamental right in a democracy." Monday, morning arrived with crowds gathered. Outside the Supreme Court hours before the decision was set to be announced. News networks lined the steps with live coverage, and Scott's blog crashed under the surge of readers, refreshing for updates. At precisely 10 a.m., Chief Justice Roberts began reading the majority opinion. "And a 6-3 decision. The court rules in favor of the petitioners," he declared, sending shockwaves through the courtroom. Not only had Crockett won, but she had also persuaded at least one conservative justice to join the majority. As Roberts continued, the legal community listened intently. He explained that, while the court had previously required proof of discriminatory intent to invalidate voting procedures under the 15th Amendment, the historical evidence in this case provided important context for determining such intent. Roberts announced a new framework. When statistical data shows a serious disparate impact on minority voters, the burden shifts to the state to prove that its voting procedures serve a compelling government interest. This approach, he noted, aligns with both precedent and the original understanding of the 15th Amendment as reflected in its congressional debates. Justice Breyer delivered a concurring opinion from the bench, an honor reserved for rulings considered highly significant. "Today," Breyer said, "the court shows that faithful constitutional interpretation is not confined to one judicial philosophy." Representative Crockett's exceptional historical research and legal reasoning remind us that the Constitution's protections for voting rights are substantive, not merely procedural. Unexpectedly, Justice Barrett also wrote a separate concurrence, joined by Justice Kavanaugh. "The statistical framework developed by the petitioners," Barrett wrote, "when viewed alongside the historical understanding of the 15th Amendment, provides a workable balance between state authority in elections and the fundamental right to vote free from discriminatory barriers." Justice Alito authored the dissent, joined by Justices Thomas and Gorsuch. "Today's decision represents an unwarranted break from precedent," he argued, relying on historical evidence that, while interesting, should not override established jurisprudence. As news of the ruling spread, Crockett's phone began to ring non-stop. President Biden personally called to congratulate her on the historic victory. Civil rights leaders hailed it as the most significant voting rights decision in decades. Law schools immediately added the case to their constitutional law syllabi. When Crockett emerged from the courthouse, hundreds of supporters erupted in applause. Reporters called out questions, but she raised her hands to speak. "Today, the Supreme Court affirmed what should never have been in doubt," she said firmly. "The Constitution protects every American's right to vote, regardless of race, and prohibits states from designing systems that effectively suppress that right under neutral language." Her tone strengthened as she continued. "This victory isn't mine alone. It belongs to every citizen whose vote was in danger. The elderly voter without an accessible DMV, the working parent who can't stand in an 8-hour line, the student whose campus polling place was closed." That evening, returning to her congressional office, Crockett found a handwritten note waiting for her. She immediately recognized Justice Breyer's distinctive handwriting. "Representative Crockett," it read, "in nearly 3 decades on the court, I have rarely witnessed advocacy that so seamlessly combines historical insight, constitutional principle, and practical judgment. You have changed not just this case, but potentially the course of voting rights law for generations. The Constitution and the nation are stronger for your advocacy. With admiration and respect, Stephen Breyer." Crockett folded the note carefully and placed it in her desk drawer. Then she turned to her staff and said, "We've won a battle, but the fight for voting rights continues. Let's get back to work." In the following months, the decision's impact rippled across the legal and political landscape. States with restrictive voting laws scrambled to adjust their systems. Law journals published extensive analyses of the court's new standard. Constitutional law professors created new case studies based on Crockett's arguments. Perhaps most notably, Crockett herself became a national figure, mentioned as a potential future Supreme Court nominee, and widely sought after for her constitutional expertise. The freshman congresswoman, once dismissed as inexperienced, was now teaching masterclasses on advocacy at top law schools. A year later, Justice Breyer announced his retirement. During his farewell remarks, he referenced the voting rights case. Even after decades on the bench, we judges can still learn something new, he said. Representative Crockett reminded me that constitutional interpretation requires both intellectual humility and moral courage. Her advocacy will remain one of the defining moments of my judicial career. When a reporter later asked Crockett about Breyer's comments, she smiled. Justice Breyer taught us that the Constitution isn't frozen in time, but its core protections endure, she said. When brilliant minds interpret it with honesty and integrity, as he always did, justice prevails. I'm just grateful to have presented a case worthy of his intellect and principles. The story of Jasmine Crockett and Justice Breyer would be studied for generations, a reminder that in America's system, a single advocate with the right argument at the right moment can reshape constitutional history. Thank you for watching this remarkable story of how Jasmine Crockett's dedication and legal brilliance earned Justice Breyer's respect and transformed voting rights forever. Don't forget to like and subscribe for more inspiring stories of justice and constitutional milestones. Tap the notification bell so you never miss our latest coverage of those defending America's fundamental rights.